not at the beginning of day 3. So for example, usually they release people at midnight. Because of when I'm placing this order and the time it is, they're not going to release you at midnight. They'll probably. All right, who's here on Brian White? Yes.
Good morning.
Good morning. So what are you here for?
It's an NPR. He turned himself in today on the warrant, but we've actually resolved. We have a recommendation for the court.
All right, so y'all ready to proceed on it?
Yes, Your Honor.
All right. Court is calling 2022 CR 8045, State of Texas versus Brian Christopher White.
We're just 30 seconds in, and already the judge is making it clear this isn't just another hearing. The charge, a third DWI, that's serious. And you'll notice no sugarcoating here.
Can I have parties announced for the record for the state? Brian Christopher White.
Andrew Harris Sadelman.
For the defense?
Tilden Schaefer for Mr. White.
You know,
Your
you're
Honor.
Brian Christopher White.
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Brian Christopher White who was placed on community supervision in 2022 CR 8045 for the offense of driving while intoxicated third or more on November 7, 2022 for a term of 5 years?
Yes, ma'am.
All right, state.
The state would like to orally amend violation of condition number 15 to read ignition interlock rather than hand device.
We have no objection.
All right.
On or about the 15th day of December 2024 in Bexar County, Texas, the defendant, Brian Christopher White, did then and there fail to comply with the rules, regulations, or instructions of the ignition interlock device, in that the defendant failed to provide daily samples in violation of condition number 15.
How do you plead to that? True or not true?
True.
State.
Here's the moment where things get real. The judge says it straight. Pleading true could land Brian in prison for up to 8 years. Think about that. Would you risk it?
State waives the remaining violation allegations, Judge.
Any objections to the waivers?
No, Your Honor.
All right, did you understand by pleading true to violation of condition number 15, the court could find it true, grant the motion, and sentence you up to 8 years in prison and up to $1,000 fine? Knowing that, do you still wish to plead true to violation of condition 15? Court would find violation of condition number 15 true. Is there a proposed agreement?
There is, Your Honor.
So, Judge, continued supervision and medical conditions to include scram and monthly home visits.
All right, so again, any objections to the court reviewing the court summary?
No, Your Honor.
All right, you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Brian Christopher White.
All right, why are you not following through with ignition interlock?
There's really no good excuse. There's been a few automotive issues, but it's, just not doing it. I don't have a good excuse because there have been a few times that I forgot. I haven't been home, but nothing that's excusable.
All right, do you want to go to prison?
No, man. I have a 17-year-old who depends on me, and I'm doing really well. I actually divorced because of her substance abuse, and I've been doing really well.
Well, you're acting as though you want to go to prison because you don't have any good excuse for not abiding by these conditions. And this has been going on since 2024.
Yeah, there's no good excuse. My first probation officer, I didn't ask, and she didn't say about how many times I had to blow.
This is what drives judges crazy. Brian's been down this road before, and yet, here we are again. Forgetting to use the ignition interlock isn't just forgetfulness. Red flag?
And the last time I had an ignition interlock, I didn't have a set amount. But you did tell me when you extended it for 6 months that I had to do it 3 times a day. And when it got cold, I had battery issues. I had to have it rewired. And there's, again, no good excuse, but I definitely don't want to go to prison.
But you're behaving as though you do, because we've been here before with this and you're still dealing with the same thing.
You will never see me again. I guarantee that.
I think that's what you said the last time. My mind is a steel trap.
This is my first.
This is his first MTR in the court. He
No,
had some supplementals.
Yes, and I do compliance hearings,
Yes.
and I tell
Yes,
people to
Your
get
Honor.
their life in order. All right, this is what the court is going to do. And state your excuse. The court is going to deny the motion, alternate amend conditions for a 6 months extension.
Notice this emotional tug. Brian asks for time to arrange care for his son. But does being a parent excuse non-compliance? The courtroom tension is real here.
And there's going to be 3 days in the Bear County Jail starting today. All right.
Like, where I can call someone to take care of my son.
Okay.
Is the 6-month extension on the probation supervision or on?
Yes, on the probation supervision.
Okay.
And then 3 days in the Bear County Jail starting today.
Is there any way he could like turn himself in at 5 o'clock or?
So who's with your son now?
He's at school.
And who lives in the house with you? And where are your parents?
At work.
All right. So are you able to call them to let them know?
Yeah.
All right. I'll allow him to make a phone call to them and let them know to pick him up.
Okay. Can he call his work as well? Because he doesn't want to lose his job.
Sure. Deputy Mejia,
Yes, Judge.
he'll need to call. He's going to go into custody today, but he'll need to call his work and his parents.
Yes, Judge.
So I'll be out by Friday, so I won't have to miss work next week.
No, you have 3 days. And counsel, you can come back and check in with the court on day 3 to make sure that he's been released.
Yes, sir.
Yeah, including today is part of the 3 days. No.
You're going in today, but this is not a full day. And the reason why I say that is because the jail is probably not going to count this as a full day. So you'll be out on day 3, but not at the beginning of day 3. So for example, usually they release people at midnight. Because of when I'm placing this order and the time it is, they're not going to release you at midnight. They'll probably put it in like 3 to 4 more hours, but you'll be released on day 3, but not in the morning at 12 a.m.
Okay.
All right.
So sometime Friday, I think is what she's telling.
Yes.
Okay.
All right.
Okay, Judge.
Do I make the phone call with him or?
Just speak to the deputies and the deputies will let you know.
So he had the warrant on this MTR, so I'm assuming they'll withdraw that warrant.
Yes.
Okay.
All right. Yes. But he's going to be in jail as conditioned. 3 days. Deputy Laura,
Yes, Judge.
on this one. She did say it as a condition. Hello.
Morning.
Good morning. How are you doing?
Good, and you?
Oh, I'm doing great. Or I should say, just fine. All right. So, state, did you tender an offer?
Yes, Your Honor, we have tendered an offer. We received the CPS records. We are going through them. We do still need to meet with the complainant and talk with maybe a couple witnesses defense provided. But we are asking for a very quick turnaround because it should be resolved.
All right. Do y'all want it next week?
Yes, sir.
Next Thursday, if we could.
All right, Norma, if you'll recall this for disposition on March 27th.
Yes, ma'am.
All right, we'll see you back then.
Thank you, Judge.
Judge.
You're welcome. Hello. All right, how are you doing today? All right, today is your plea deadline date.
Quick legal insight. If you're already on parole and take time on a new case even, if it's unrelated, you can lose parole entirely. Judges know this. Defendants often don't.
Have you all reached an agreement?
Judge, we got an offer from the state. It's a good offer, and we are liking to accept it. My client has a parole. He's on parole. I would like a just brief, if I may, continuance to speak with the parole officer to see what effects a plea would have on his situation. Considering it's a time plea, I don't believe that would serve.
Well, if they're doing it, I can tell you the impact it's going to have because I've done parole hearings. If he's taking time on this case, they're revoking his parole. They're not going to keep you on parole while you're at the prison for something else. I've never seen that in all my years. So today is plea deadline date. So either y'all are entering a plea today or you all are going to trial today. That's why he's brought over dressed for trial.
I could get a week till next Thursday with my other case to
Today is
give a chat.
today's plea deadline date or trial date.
Yes.
Okay. So do y'all are, oh, I'm not
We'll go
going to
check.
trial yet.
We'll go
You
check.
talk to them. Joseph Garrison. All right, Abel Favala. Yes, counsel.
Ready to proceed, Your Honor.
All right, so there's a judge's warrant by Judge Glenn.
Yes.
And, this is for restitution. Are there any witnesses for restitution?
Judge, so as part of the defendant's plea agreement, he agreed to pay the restitution. We have received a medical bill from the complainant. Unfortunately, our advocate went out and she was just able to provide the rules to the defense to the victim today.
Mhm.
And so if he's not logged on, then
Let me see. Yeah, they're not logged on. Well, counsel, have you had a chance to see the medicals? Do you object to the medicals?
We object, Your Honor, without proper authentication, without a proper sponsoring witness with regards to the matter. And this has been, I believe, either the third or fourth time this matter has been rescheduled for, Your Honor. So we're ready to proceed with the restitution hearing.
And Judge, I just want to address that very briefly.
Mhm.
The first couple of hearings that we had were reset because the defendant was in in lifetime recovery.
Yes.
The state did not object to the resets at that time, and our witness was available on these dates. On one date, the witness was present via Zoom and was excused because the defendant was in lifetime recovery at that time. I could have tried to urge that he be put on at lifetime recovery, but in consideration for his treatment, I decided to release that. And so I know that the court, I didn't come before the court at the last setting, and that's just where we're at. I just
Your Honor, if I may respond, the first setting, he was in lifetime recovery and there was an agreement to postpone. It was also set a second and third time. One of the times because Ms. Galloway was ill, and I did confer with Mr. Edelman, and he was privy to that information regarding the hearing. And then the last hearing is just simply, it just got reset. So we're here now. I know the court indicated this would be the final one. The last one I could have urged that, there'd be no more continuances regarding this matter. I was respectful of the fact that they had to allow us, and see within a lifetime, to get a reset. So we were working with them as well. But something's got to give at this point, Your Honor. The case has been closed. He's placed on deferred adjudication, and I frankly have other matters to deal with.
All right. So this is what I'll do, because I do understand that there have been reset requests for both sides, back and forth, back and forth. And I understand that the court did say this would be the final restitution setting. But I also understand that there's somebody, a complainant, who has medical bills, and those need to be paid because you're the cause for them having medical bills. You understand? So this.
Judge, and I, yes, and I will, and I want to thank you for giving us the reset because the complainant, and it's the fault of us because I wasn't here.
How long do you all expect this hearing to last?
It should be brief.
Yeah.
All right, counsel, are you able to be here tomorrow at 9 a.m. and you will be the only case other than the jury trial that's on the docket, or either I can set it in the afternoon at 1:30.
I could be here tomorrow, 9 a.m. Judge.
All right, so we're going to recall this tomorrow at 9 a.m. That will be the last setting for restitution hearing. If the complainant is not here at some point, this must end.
Thank you, Judge.
Yes, Your Honor.
All right, so we're going to bring you back on March 19th. And counsel, if you would like, we can have him appear by Zoom or he can appear in person.
In terms of my client, Judge?
Yes.
Whatever's preferable to the court. I know that felony drug court said that they were going to meet with him tomorrow. So if by Zoom, I think that might be better. So there's no kind of please over here. So felony drug court's not able to see him.
All right, so we'll have you appear by Zoom.
You're either going to drug court or you're going to prison. That line sums it all up. In court, choices are clear. Freedom comes with conditions, and defiance has a price.
And counsel, if you let felony drug court know he's going to appear by Zoom,
Yes, ma'am.
because I don't want to interfere with whatever treatment or what they're doing with you. All right.
Yes,
All
sir.
right. And
Complainant, we have previously agreed that he didn't appear via Zoom.
yes.
That's fine. We previously agreed to that, so we'll agree to that.
All right. So witnesses and the defendant by Zoom tomorrow at 9 a.m.
Yes, Your Honor, that works with us.
All right. Thank you. And counsel, if you want to appear by Zoom, if you don't have court downtown, you can appear by Zoom as well.
I have court in another right here courtroom down the hallway, Judge, so I'll be close. So I'll be here in person. But I
All right.
appreciate that,
Thank
though.
you.
In front of the judge.